Understanding how to legally terminate a contract is essential knowledge for anyone involved in business agreements. Contract termination is not as simple as deciding you no longer want to be bound by an agreement. It involves specific legal grounds, processes, and potential consequences that must be carefully considered. Contracts can be terminated for various reasons. These include breach of contract, impossibility of performance, mutual agreement between parties, or force majeure events like natural disasters or acts of war. Each type of termination carries different legal implications and requirements. Before considering termination, you must understand the specific provisions in your agreement. Many contracts contain termination clauses that outline the conditions under which parties can end the agreement. These clauses typically specify required notice periods and potential financial obligations that continue after termination. There are two primary categories of contract termination: termination for convenience and termination for cause. Termination for convenience occurs when one party ends the contract without the other party violating its terms. This type of termination is only possible if the contract specifically includes a clause allowing for it, often called a termination for any reason by notice clause. Government contracts and large corporate agreements frequently include such provisions. Termination for cause, on the other hand, happens when one party breaches the contract, fails to meet essential obligations, or engages in misconduct. In these situations, the non-breaching party may terminate the agreement and potentially seek damages. Before terminating a contract for cause, you should verify that the problem relates to a crucial part of the agreement, is sufficiently serious, and is caused by the other party. The process of terminating a contract requires a structured approach to minimize legal risks. First, thoroughly review the contract to identify termination clauses, notice requirements, and financial obligations. Next, provide written notice according to the contract specifications, ensuring you retain proof of communication. When possible, negotiate an exit strategy with the other party, which might include amending the contract rather than terminating it outright. Be aware that some contracts, particularly in regulated industries, require specific legal procedures before termination. Consulting with an attorney before taking action can prevent costly mistakes and ensure compliance with all contractual obligations. Terminating a contract can have significant legal consequences. If you terminate without proper legal justification, the other party may sue for breach of contract and seek damages. Many contracts impose early termination fees or penalties, and termination may result in the loss of rights to intellectual property or other contractual benefits. You might also be required to return property, materials, or confidential data upon termination. Rather than proceeding directly to court when disputes arise, parties often seek alternative dispute resolution methods. Mediation involves a neutral third party, helping both sides reach a mutually agreeable resolution. Arbitration results in a binding or non-binding decision made by an arbitrator and is typically faster and less expensive than litigation. Direct negotiation between parties can also resolve disputes informally. These alternative methods can reduce legal costs and help preserve business relationships. Contract termination is a complex legal process with significant implications. Understanding the legal grounds, following proper procedures, and considering the potential consequences are essential steps before ending any contractual agreement. When in doubt, seeking professional legal advice is the best way to protect your interests and ensure compliance with all legal requirements.